Without further ado, I am going to introduce our first speaker. So Megan Blake is an Australian lawyer and academic. She's on the management committee of Feminist Legal Clinic and Maternal Scholars of Australia and works primarily in the areas of human rights and the protection of women and children. Megan is currently on the team representing the Lesbian Action Group in their appeal against the Australian Human Rights Commission to be heard later this year. And Megan is going to tell us about the WDI submission to Reem Alsalem on new forms of violence against women and on the issue of consent. So thank you so much for coming on today in the middle of your night, and over to you.
In late 2024, the United Nations Special Rapporteur on Violence Against Women and Girls, Reem Alsalem, put out a public call for input into her thematic report that she's going to make to the Human Rights Council at its 59th session in June this year on, as Jo said, new frontiers and emerging issues in sex-based violence against women and girls, and an addendum to that report specifically on the issue of consent. Each submission was limited to 3,000 words, and the deadline was the 30th of January this year. WDI produced one submission for each of the main report and the addendum. They can be found on the WDI website under the News tab, posted on the 9th of February this year. So please visit womensdeclaration.com and navigate to the News tab if you would like to read through the submissions, and you may want to do it in partner with this webinar. So these submissions were different from other recent ones that we've done in that they were not directed to their final audience and were not written with the primary goal of persuasion. The Special Rapporteur wrote in her preliminary comments that sex, for the purposes of her report, was to be understood as a biological category, and that this meaning of sex was the most consistent with both the treaty instruments relevant to human rights and with the ordinary meaning of the word. We didn't, therefore, need to address this conflict in our submissions. We didn't have to justify why a focus on biological sex is important, and we could move past that to substantive harms affecting women and girls as a result. The Special Rapporteur has also published opinions on matters such as pornography and prostitution that are largely in line with the WDI declaration. So we could take her understanding of and agreement on these issues as a given too. In many other submissions to organisations and committees where there is not agreement on these points, even for instance with the CEDAW committee, we cannot take these as a given and they need to be addressed every single time. So they didn't need to be addressed here. Finally, the submissions were requested by the Special Rapporteur for the purposes of informing her own report, but she would be the ultimate filter and selector of the final material put to the Human Rights Council. Therefore, if we were aware of an issue being raised by another submission, such as Sheila Jeffries' own submission on the harms done to women in the workplace who are compelled to participate in the fetish of a man's paraphilia, we didn't need to address that in as much detail or at all. If the Special Rapporteur's attention was already being brought to it as a concern in the community, we could trust that she would do with it as she thought best. We therefore brainstormed more issues relevant to each call for input than we ended up including in our final documents. So firstly, I'd like to run through the issues we raised for the first submission on new and emerging frontiers in sex-based violence against women and girls. So we addressed our submission to 4 of the 14 questions posed by the Special Rapporteur. Firstly, are there emerging forms or evolving dynamics of sex-based violence that call for a deeper and more nuanced understanding? Secondly, what forms of sex-based violence are under-recognised or underreported? Thirdly, how are language and terminology today being used to describe sex-based violence against women and girls, and what are the implications of this usage? And fourthly, what are the challenges, including gaps in legislation, What are the opportunities and what are the best practices in combating sex-based violence? So on the first question, the forms of violence requiring a deeper and more nuanced understanding, we suggested 3 topics. Firstly, the way in which we conceive of the term sex-based violence. In her call for input, the Special Rapporteur defines sex-based violence as violence that has affected women and girls disproportionately because of their female sex. So we commended this definition in its broadest construction because it describes a kind of sex contingent type of violence that is wider than only violence grounded in the act of sex or reproduction. It encompasses violence that affects women and girls disproportionately. For instance, medical interventions performed on a girl who identifies as male are dependent on biological sex. The interventions are directed to her sex markers and reproductive system, and girls are disproportionately likely to be young lesbians, the victims of sexual abuse, or the trauma of sexual objectification, or some combination of these. So we submitted that the concept of sex-based violence is itself an area in which greater nuance is often required, as harms disproportionately suffered by women and girls can too easily be dismissed as sex neutral because they're not overtly sexual. Secondly, we argued that the question of housing males in the female prisoner state required a more nuanced understanding, specifically by the general public and UN member states. Currently, this housing is seen as a kindness and a human rights commitment because men who identify as women are considered to be significantly at risk in the male estate. We argued that it needed to be considered from the perspective of the women in the female estate instead, and as a victimization of those women, a human rights violation rather than a human rights protection. We argued that it resulted in the oppression of women and therefore breaches of the United Nations rules for the treatment of women prisoners and non-custodial measures for women offenders, which is known as the Bangkok Rules, and the Mandela Rules, which is the UN standard minimum rules for the treatment of prisoners. And we gave examples and statistics from Australia and the USA to demonstrate the fact of this placement happening. Thirdly, we submitted on the way in which prostitution and pornography have worked to normalize violence as part of sexual intimacy. Now, the Special Rapporteur herself published on this in May 2024, so we did little more than commend her own report to her. Stating our support was important, however, because she is currently facing attacks in retaliation for this report. On the next question, forms of violence that are currently under-recognised or under-reported, we submitted on only one point here, the nature of gender-affirming medical interventions as themselves forms of violence, particularly in relation to children and vulnerable adults. We argued that since social transition, hormones, and surgeries are all unproven, and studies worldwide are impaired by inadequate follow-up times, high dropout rates, full and proper disclosure cannot be made. The impacts of social contagion and the nature of trans identification as a response to trauma or social dysregulation then further impair the capacity of any child or vulnerable teen to give proper free assent. We submitted that there are social forces conditioning children to identify out of their sex and even rewarding them for doing so, and that gender interventions differ from other experimental or risky treatments because they do not produce a child who is more physically healthy and less impaired than before. On the third question of language and terminology, we picked up on the Special Rapporteur's own point of the difference between competing definitions of sex and the erasure of biological sex in language, and even now saying biological to avoid ambiguity demonstrates the linguistic issue that we are facing. Now, these arguments are well known to us all, but in the submission, we drew specific attention to the way in which the change from sex to gender has allowed UN member states to undercut the sex-based protections they owe under international law. Ideally, the Human Rights Council in June would want to understand the way in which its own use of language is permitting member states to avoid obligations that they owe under treaties that the Human Rights Council supports. And finally, on the question of challenges, opportunities, and best practices, we focused on the challenge posed to data collection by the corruption of sex class data. Despite international recognition that this data is necessary for proper policy development and monitoring. We gave, as an example, the results of the Freedom of Information request submitted by Fair Play for Women to UK regional police forces in 2019. Over half the forces that responded replied that crimes data was recorded under self-declared gender rather than biological sex. And in their crime survey statistics for England and Wales for the period March 2017 to March 2020, the Office for National Statistics reported that 1.5% of rapes by penile penetration had been committed by people recorded as women. So that's a summary of the first submission. Moving on to the second one, I will say a little less about the second submission on the issue of consent because it's on a single topic, but I'll just outline the key points before I go. Firstly, we asked that the Special Rapporteur broaden the application of consent in relation to sex-based acts to situations contingent on biological sex, and not just limit it to situations that involve manifestly sexual or reproductive acts. So this would, for instance, encompass consent in situations such as sex change procedures on girls, because they are contingent on biological sex. And this therefore tied in with our submissions on new and emerging forms of sex-based violence, so the submissions work together. Our primary submission in relation to the definition of consent was that the current contract model is inherently flawed and needs to be replaced. Consent is currently thought of, and this is across different jurisdictions with slightly different language and law. It's thought of as a transaction largely of offer and acceptance. Now, firstly, this is unidirectional. It goes in one direction, which is not a model of healthy intimacy between two equal partners. It also ignores the reality that women are often coerced into giving their assent, and it encourages the practice of wearing her down by persistent offers until a no turns into a yes. Secondly, it's also flawed because it characterizes the relationship as a private agreement that involves minimal public interest considerations, and therefore it favors the party with power in private. Contractual consent conceives of the private as private, instead of the private being also public. Thirdly, there is therefore an over-reliance on pure individual autonomy, as though we have no social, no emotional, and no interpersonal context influencing our choices, and as though differences in size and power between women and men mean nothing. Ultimately, the question is not asked, what happens if a woman nominally gives her consent to things that harm her, and by extension, harm women as a class and the broader society? Now, there is no easy answer to this question because we do run the real risk of paternalism if we take it too far, of treating women as less than competent adults, able to exercise their own choice and give or withhold consent to acts that affect their lives. And yet, we submitted that there was an important class-based interest in weighing the foreseeable harm likely caused by the act against the fact of the woman nominally consenting to it. We also identified the way in which we can overestimate capacity to consent in situations such as gender-affirming medical interventions and with women housed in prisons and trafficked women who can give no really meaningful consent, even if they superficially say yes, because of the situation that they're in. Now, this could be extended to include women in all kinds of structurally coercive situations, such as women in the workplace who fear losing their jobs or fear disciplinary action if they reject participation in a man's gender identity, or girls in schools who are forced to share change rooms or sleeping quarters with boys and young men. The balance is difficult to achieve, and yet we think it is something that is worth thinking about. Now, it's a current trend for jurisdictions to attempt to fix the problem of consent by adopting an affirmative consent model. But we submitted that this was often an easy fix that avoided the core concern. An affirmative consent model raises the bar for communication of the consent, and it requires that this consent be expressly and positively communicated. So silence is not consent, acquiescence is not consent. But requirements for the communication of consent do not solve any of the problems inherent in the idea of consent itself. If a prostituted woman affirmatively consents to intercourse, she has communicated it, but she is economically and socially coerced. A young girl who is told that choking or anal sex are normal and expected parts of intercourse may also affirmatively say yes. But do we think that this is meaningful? Do we think this is an absence of violence because affirmative consent standards have been reached? So we therefore recommended a model that repositioned consent as a necessary but not sufficient element, and suggested a totality of circumstances model that better weighed assent against the surrounding circumstances of perhaps coercion, and also the likely impact or harm of the act. Wrongdoers ought to be liable for choosing to commit acts that place women and girls in situations of reasonably foreseeable harm, even if the victim of that harm provides her technical acquiescence to it. Now, by all accounts, the Special Rapporteur received tens of thousands, hundreds of thousands of words in response to this call for input, and she is working through the pile now. So we look forward to seeing what she selects for her report in June. And in the meantime, please head along to the womensdeclaration.com website, go to the news tab, and on the 9th of February, links to both of our submissions were posted. Thanks very much, Jo.